Welcome back to the Law and Crime Network. I'm Heather Hansen, and that was some of the most difficult testimony that we've heard thus far in this case of Ohio versus Shawn Grate. That was the testimony of the victim who survived his brutal raping her and beating her and had to testify to the same there in that courtroom. I want to bring in our fabulous guest and so point on for this particular case, Stacey Honowitz. Stacey, thank you so much for being with us during this especially difficult case. I want to ask you about that witness's testimony because it was obviously, extremely vulnerable, hard for her to testify, and much that she couldn't remember about details. I'd imagine that that is pretty normal for someone who's been a victim of this type of heinous crime.
We see this day in and day out. First of all, you could hear her breath. It was palpable. You could hear how devastated, how difficult it was for her to testify, which we see all the time. And, whenever a defense attorney, because I can assure you that, a line of questioning will be given to her that you couldn't remember and you didn't know and what was going on. And I always get up and say, do you think that they have a notebook with them, just in case we're going to get raped that day? Oh, he touched me 5 times, my left leg, my right breast, my left, just to show the jury kind of how ridiculous some of the questions can be when you're in the throes of being raped, kidnapped, beaten, and tied. So, it is the certain victim that does have that ability to kind of be in shock and kind of take it all in. But for the most part, you will get a victim who's been through a devastating experience like the one that you're hearing now that really will experience that. I don't know. I'm not sure. I saw his penis. I know it was out. But, Heather, you also have to imagine how difficult that kind of testimony is to begin with, to have to talk about your private parts and being violated and what went on and how many times. I mean, it's devastating for anybody to have to talk about that outside kind of a courtroom, and you really don't ever get into that conversation. But now you're in front of a judge, defense lawyers, the defendant, a clerk, a court reporter, jurors, people walking in and out, press. To have to discuss this, it's a very, very difficult situation, and that's why we like when our victims kind of go to therapy beforehand, not to have somebody put words in their mouth, but just kind of to get them acclimated to the courtroom setting and have to discuss this and talk about this kind of stuff. So what we're seeing today is not unusual at all.
Stacey, it's really interesting that you bring up that point. It reminds me of the last time that I spoke to you. You've written books about how to have conversations with children about these types of things. Isn't that right?
Yeah, that's correct, because, so many of my cases aren't adult rapes, and certainly we have those, but majority of what I prosecute has to do with little kids that are sexually abused. So I wrote the books because we all know how difficult it is to have that discussion. I always say, and my mantra is, it's parental malpractice if you don't have the discussions with your kids about being violated in private parts and anything that goes along with that.
And in many ways, we can hear, as you said, we can hear in the tone of voice of this victim that in many ways it's just as hard for an adult to get up and stand in front of a room full of people. And we could see that it was a full room full of people, many of them men, and talk about this type of heinous thing. Do you find that you as a female are really better able in some cases to relate to the victims, and that they're able to open up to you in a way that perhaps they wouldn't be able to open up when talking about private parts and rape and all of these types of things when it's a male prosecutor?
I think that, we've had our share of male prosecutors in my division. I'm there, close to 30 years. And in the time that I've been in that unit, there was only one male prosecutor that came to me and said, listen, I can't handle this. I can't have a 4 or 5 or 6 or 7, a little girl or even an older woman in my office and discuss this. I don't know if she doesn't want to open up to me. I don't know if I have it in it to really kind of take it all in and ask the proper questions. And that's really been the only time. But that's really left up to the victim themselves. There are people that come in and say that they only want to talk to a female, and that's understandable. You see that in cases when it's a male detective that goes in. Plenty of times they'll call in a female detective to kind of do the questioning because they know that there might be a comfort level there. So it really depends on the person. It depends on the prosecutor. You kind of have to have a thick skin and kind of have to be an empathetic person and willing to let these people talk to you and kind of take it all in and listen to them.
Yeah, which has got to be so difficult to take all of that in and all of this, because I know even we here, as we're watching this case, myself and the producers, it's hard not to be affected. It's hard not to take it home with us at night. It's hard not to have dreams about these terrible, heinous crimes. I can only imagine 30 years of doing this for you. How do you find a way to put that line at the end of the day so that you're able to function in your own personal life? Or is it something that does sort of creep in and overlap?
It certainly creeps in. It certainly overlaps. You never really go home with that feeling. If you're in trial, you're living with what you didn't do in the courtroom, what you should have done. What did I do wrong? Did I say that right? You know that as a trial lawyer. You're always second guessing yourselves. God forbid you lose that case. I didn't go to work once for a week because it was just you develop an emotional attachment to these cases and to these victims, and you are their representative. You don't want to let them down. They realize that it's the jury, but you take a very strong role in how you presented it. Did I do it wrong? Did I do it right? So, and it does creep over. I think it does take a toll on a lot of things in my personal life, and how I conduct myself, how I see things that maybe other people don't see. I'm kind of on the fringe, on the edge, because I see things, like I said, that other people might not notice. So you never really quite get away from it. I always tell everybody, everyone always asks me, how do you deal with it? And I tell them I should have stock in Hershey because it's been very good to me, not good to my body, but it's been very good to me in trying times.
No, listen, sometimes it's whatever it takes to get you through those sleepless nights. And,
Right.
I agree with you. I know that when I feel as though, I've missed something in court or a bad result, and it's that much, I think when it's human capital that you're talking about and victims, it's got to be really difficult for you. In this case, I want to, in just a minute, we're going to show another clip, but then I want to talk to you about defenses and how in the world these defense attorneys are going to be able to defend this case, and also this idea of maybe the insanity defense coming up and whether that's applicable in sexual assault cases. So I want to talk to you about all of that, but first I want to play, Virginia, our producer, and I were talking about the need for sort of some uplifting testimony in this case, and one of the things that a lot of us enjoy is the fact that this woman was able to break away. She was able to escape. She was able to save her own life, and in the process, make sure that Shawn Grate was captured and perhaps save a number of other women that could have been his victims. So we're going to play some testimony about that, her escape, and then we'll come back and get some more of Stacey's insight. Welcome back to the Law and Crime Network. I'm Heather Hansen here with Stacey Honowitz talking about this Ohio versus Shawn Grate case. And that was the testimony of the victim who was able to get away. She was able to escape. And, not only was she able to save herself, but by making the call to the police and allowing for Shawn Grate to be caught, she may have saved many other women. Stacey, we talked a little bit about how the cross-examination of this witness might go, and we're going to play some of that cross-examination in just a minute. But what are your thoughts with respect to how the defense is putting on this case, and what are their options in a case that seems such a slam dunk?
Well, I don't know if they pled the insanity defense ahead of time, because I can't imagine the two of them sitting there what they could possibly be thinking as far as how we're going to get him off of these charges. Certainly the cross-examination of this person is going to be what I talked about before. Well, how do you know? And you didn't know how long, what time it was, what day it was, how long he was doing this. You don't even know if he sexually assaulted you. She said at one point she didn't know. His penis was out, but she didn't know where it went. So all these different kinds of things to kind of trip her up, which it's not going to work. And I just think that maybe they're going to, if you heard I could hear some of the transcript of the confession to the detective.
Yeah.
She was asking kind of very poignant, some of the questions, almost to kind of get into his mind.
Right.
Maybe she was realizing that he's going to try to say he was insane at the time. So she was kind of trying to pull out these questions from him, because I think probably that's the avenue she thought they were going to go into. I don't know in Ohio. I know down here you have to plead insanity prior to ever go. It's not going to pop up in the middle of trial. I just don't know if here that's kind of where they're going with this.
Yeah, it seems as though that would be their only option. But, we talk a lot about insanity as a defense to murder. And I don't know that I've ever seen insanity as a defense to, my phone. I don't know if I've ever seen insanity as a defense to a sexual crime. Is that something that you've seen in your practice?
Yeah, Yeah, I mean, it's few and far between, but I have seen it. And like I said, down here, you have to plead it way ahead of time, the insanity. And certainly you have to have different various doctors come in. Certainly we're going to get state doctors and we're going to get defense doctors, and they're going to make a decision as to whether or not the person, knew the difference between right and wrong. And I have not seen, in the years that I've been in that office, I have not seen the insanity defense be successful against a sexual assault, but certainly there are defense lawyers that will say that that's the case.
Yeah, I would think that, it's hard enough to prove in a murder case, but in a sexual assault case, to prove that the defendant didn't know the difference between right and wrong, and that's sort of the standard in Ohio. On top of that, given that he's confessed and sort of said that he knew it was wrong, it's a difficult defense to raise. And I should point out for the audience, in Ohio, it's an affirmative defense, which means that the burden is on the defendant to prove that he was insane, rather than on the prosecution to prove that he was not. So a lot of very high hurdles to overcome there. Stacey, in a case like this one, it's almost like the prosecution has a pretty straightforward, and I would even dare to say easy job. Does that make your job any easier when it seems as though it's open and shutter, or is that even more stressful? Because then
that's really...
Go ahead.
Just like you're going to say, I'm sorry to interrupt you. Therein lies the stress, because we know never to say we have a lock case, because there are no cases that are lock cases. You never know what's going to happen. But certainly, I think it goes both ways. It's a double-edged sword. You don't feel the pressure because your evidence is there. Yeah. Your evidence is solid. If you have a confession and it hasn't been kicked out prior to, and you're going to play it, it's solid. If you have DNA and it hasn't been tainted, there hasn't been an issue beforehand, the defense has tried to move it out, and you've been successful in keeping it in. So your evidence is in play. It's a matter of sitting down after your closing argument and saying, did I say everything I needed to say? And that's what it is. But yes, I mean, certainly if you have, the more evidence you have going into a case, the easier it is to prove to your jury. That even just came out. It's very interesting. If I can digress for a second. Of course. There was an interview with one of the Cosby jurors that came out today. Yes. And the juror said, listen, he said it in the deposition, I give pills to have sex. So, I mean, you go into a case like that, you've got something solid to present to a jury. And that's what you're hoping for in a lot of these cases. That's why our evidence, our DNA evidence, is so crucial. Not so much when we have a consent defense, because if it's a consent defense, you'd expect to see DNA. But when we have a stranger case, or of course when the victim says, I absolutely did not consent, I did not want to have sex, and then there's DNA. So there's, this, you've been a trial lawyer for a long time, there's various ways of arguing and spinning things, and I think that those guys are probably just sitting there going, oh my God, when is the last day of this case? Yeah, no, listen, I couldn't agree with you more. In the cases where the evidence all seems to be there and you feel like everything is well locked up, you just keep looking at the jury hoping that they see it the same way you do. Right. Because it just seems so obvious. And that's how I think most of us watching this case feel, that it just seems so obvious. I do want to play now the cross-examination of this victim, because, one thing that we need to point out is, for a defense attorney, they have a job to do, and under our Constitution, we want people to be representing both sides, and so they did attempt to cross-examine this victim. I want to play a little bit of it and then talk to you about whether or not it was effective, and if there was anything that even could be effective with a witness like this one. So let's play that, and then we'll come back and get more of Stacey's insight. Welcome back to the Law&Crime Network. I'm Heather Hansen here with Stacey Honowitz as we discuss the Ohio versus Shawn Grate case, and we are watching the cross-examination of the Jane Doe victim. That's why we're not seeing her face, who was able to get away while we wait for them to come back from their lunch break. Stacey, it does seem as though perhaps the defense is trying to set this up for some sort of a mental defense when he talks about how Shawn acted different and all of a sudden was acting crazy. Do you think that's where he was going there? Yeah, I think that's probably the only thing that you really can assume from this. Like a brief reactive psychosis type of thing, that she had this, I don't want to say relationship, but she thought she knew his demeanor. She never at any time really goes off course and says, oh, he's been crazy, he was nuts all along, I had to fight him off, I had to get him out of my house, he wouldn't take no for an answer. She pretty much goes along with what the defense is saying, but then yes, there's all of a sudden this quick change. It to me seems like there is some kind of mental issue that's going to pop out somewhere.
Yeah, it's fascinating, and it's always frustrating to me. I can't think of a situation where I have waived my opening, but the defense did do so here, and so we don't have a good sense. I mean, to your point, we don't know where the defense is going with this case. Do you think strategically that was a good idea in a case where the evidence is so overwhelmingly against them?
Yeah, you know, I had one case where, and it was a very well-known defense lawyer, very popular in my county, where and it was a high-profile case. It wasn't an adult rape. It was a teacher, a female teacher having sex with a male student. So it was very high-profile at the time. It was one of the first ones. And he waived his opening statement. And I was kind of, you know, that's kind of difficult because you don't know really, you know, in the depositions that went on before, I kind of knew where he was going, but certainly if they want to kind of save it for their side of the case, it usually is because there's overwhelming evidence and they feel that they need to make an entire presentation, wait and listen to the state. Now I'm going to tell you, you know, I wait and listen to my evidence and see where it goes. So yes, I think you're right. I think it has to do with the fact that the evidence is overwhelming in this case. They kind of have to see where it goes, kind of like flying not by the seat of their pants, because I'm sure they're prepped, but you never know what's going to happen in a courtroom. So rather than do an opening statement and then not live up to what you say in your opening statement, they kind of wait and see what happens.
Fabulous point. Stacey, they're live back in the courtroom. They're back from their lunch break, so I'm going to take our audience there live. If we have the opportunity to have you back again during a break before you have to leave, we will. But just in case, I want to thank you once again for your amazing insight on this really difficult topic. Thank you.
It was my pleasure. Thanks for having me.
All right, ladies and gentlemen, we're going to take you right back to that courtroom. We'll be back during the next break.